Hi, I'm Anna Jones of Refreshing Law Limited, and in today's session I want to talk about the situation where you need to decide if somebody's got a disability or not. Often a problem for employers because ultimately we don't really know under the legislation until we've got to the point of a court decision as to whether or not somebody is disabled or not. So an employer often finds himself having to take medical advice, perhaps getting some legal advice to try and determine whether or not they think somebody has a disability. Often I would advise somebody to err on the side of caution, and perhaps if you have any concerns, treat somebody as if they are disabled, and that way you're less likely to find yourself liable, for example, for not making reasonable adjustments. There's been a recent case involving this of Gallup and Newport City Council, and what had happened in that case is that Mr Gallup had stress-related symptoms that he said were connected with work, things like loss of appetite, sleeplessness, nausea, etc. And when he was sent to Occupational Health, they said he wasn't covered by the Disability Discrimination Act as it was then. So the employers relied on that. But there was also evidence from Mr Gallup himself in a grievance that he raised that he considered he was suffering from depression, and there was evidence from his GP that he was suffering from what was labelled reactive depression. So although stress in itself, and sick notes, for example, with just stress at work and things like that on them, is not evidence of an illness necessarily of itself. Stress is just a state. It can go hand in hand, obviously, with a background medical condition, and sometimes we need to dig further to find out more about that. In the particular case, the employer had relied on the occupational health report to then not make any reasonable adjustments, for example, and they got into trouble for that. And it's very interesting that the judges in the Court of Appeal have really emphasised that employers can't just rubber stamp what occupational health are saying. So whilst you may be looking very much to them for guidance and for them to give you an answer to the question whether or not there's a disability, you need to apply your own mind to it, and it's your judgment that you have to come to, having taken some medical advice, having taken legal advice, and looking at all the circumstances that's in front of you, including what the employee is saying to you. In the case itself, Lord Justice Rimmer in the Court of Appeal emphasised that employers shouldn't just be sending occupational health sort of standard form with a please comment on whether or not this person is disabled type question. You really do need to make sure that the answers you're getting from occupational health break down the test of a disability into the different elements, so whether or not there is an impairment and the details around that, the extent to which it may or may not be a long-term condition, the extent to which it has an effect on somebody's ability to carry out normal day-to-day activities, and how substantial and significant those impacts are. So not only do we need to phrase our questions around that, but we also need to think in any individual case about questions that relate to the information perhaps we've been given by the employee, perhaps by the GP if we're sending it out to occupational health. So it's very much a tailored approach to try and get the best answers back in that situation. If you have any questions, please do not hesitate to email me. It's adenton@refreshinglawltd.co.uk. Thank you very much.